So students, we're in chapter 12. You've already heard the brief intro to chapter 12. This will be the final chapter for Commercial Law 1. So congratulations on making it this far through the course. Hopefully you found it, at the very least, somewhat interesting, somewhat rewarding. To some of you, you may find it somewhat frustrating. But these are the things that you need to know in order to be able to, on a very basic level, understand the immediate issues that could arise in a business environment. And I strongly encourage you to keep the text that you have here, whether you're going to go on to Commercial Law 2 or just for your general use for the future, because it goes on to define other types of legal relationships, including in the section after this, stuff with regard to the concept of agency. But notwithstanding, in chapter 12, which is titled Other Torts, we deal specifically with business-styled torts, as well as one other more generic general tort, which will come toward the end of this chapter, called defamation. And it's something that falls near and dear to me because for several years I did what's called free speech law. And free speech law involves this notion of defamation. We'll get to that in a few minutes. You'll see the introduction to it. They give you, just like they have in the previous chapters, the hypothetical situation to help you further understand the concepts that we'll be discussing. Again, I strongly encourage you to read that over in order to enhance your understanding. But we talk about, in the introduction itself, on page 267, business activities. They give us several different examples with regard to tortious conduct. If you don't understand torts yet, please go back to the previous lessons right before this, and hopefully you can establish or reestablish your understanding of what is a tort. You'll see toward the bottom of page 267, the text gets into this notion of tort and property use. And the first concept that they define for you is this notion of occupier, someone who has a degree of control over land or buildings on that land. So that's easy. Right now, I am an occupier of this room at SMU, or I'm an occupier of this building at SMU. I have no real property right here, aside from the fact that, as we'll go into it, I have been invited to be present in this room. An occupier can be somebody who is there legally, and in theory, an occupier is somebody who could be there illegally. We're going to be discussing that a bit more. Occupier's liability falls on page 268. And it talks about first, under the first subheading, liability at common law. If you recall, way back when, we defined the common law, which is this long set, historically, of case law that was passed down by British judges over the course of literally hundreds of years, that helped to define what are the rights of people under certain circumstances. In the absence of a written law, a statute, normally what courts will do is they will resort to reviewing what the common law says on a given situation. So we'll see under the common law, there's this notion of what is a contractual entrant. Any person who has paid, contracted for the right to enter the premises. A contractual entrant. Think of anything from somebody who is going into a restaurant, somebody who's going into a theme park like Disney World. They are a contractual entrant. They have paid for the right to be able to come onto the premises. Right under the notion, they break down what a contractual entrant is a little bit more right under that. They discuss two different terms, one being an invitee and the other one being a licensee. And you'll see the definitions for that on the left-hand bar of page 268. An invitee is defined as any person who comes onto the property to provide the occupier with a benefit. Also, you have a licensee, any person whose presence is not a benefit to the occupier, but which the occupier has no objection. So, if I have a contractor, if I have a handyman coming into my house in order to provide me with some type of special service, maybe it's the installation of a new kitchen, then that person is what? That person would be considered an invitee. They have been invited by me to come in a manner which will ultimately benefit me. If you have, old grandma or grandpa coming in, now, although there may be some type of what we call an intangible benefit, like you love your grandparents when they come in and you're happy they're coming over to your house, so they provide you with a tangible, concrete benefit by coming over to your house? Probably not. And so therefore, they are not defined as being invitees, even though you may have invited them. They are instead defined under the common law as licensees. And so those two concepts and the examples that follow will tell you what the rights of an invitee are, as well as what the rights of a licensee are. Do you have obligations to both invitees and licensees who set foot on your premises, on your property? The answer is generally what? Yes. Now, do you have an obligation, some type of legal obligation, to somebody who is attempting to occupy your property unlawfully, such as you'll see on page 269, a trespasser? And you'll see what a trespasser is. It's defined in the right-hand bar. Do you have some responsibility to the trespasser? And the answer is what? You would think no, but you do have some residual responsibility even to a trespasser. The occupier, as is noted in the book, will be liable for any act done with the deliberate intention to harm the trespasser, or an act done with reckless disregard for the presence of a trespasser. Though the trespasser is not owed a common law duty of care, the occupier does at least owe him at least the duty of acting with common humanity towards him. And the example I like to give is several years ago, we're talking probably over 30 years ago, there was a situation where I come from in Florida where there was a crime-ridden section of the city of Miami. And there was a guy who owned a convenience store that had been broken into several times. So ultimately, instead, the bars on the windows didn't help. Ultimately, what he decided to do, the owner of the store, was to electrocute the rooftop of his building, of his store. And as a result of electrocuting the rooftop, of electrifying it, a burglar ended up stepping onto the rooftop and being electrocuted and killed. Did the store owner owe that trespasser, who intended not just simply to trespass, but to actually supposedly commit a crime inside of that store, was that store owner, did they owe that burglar a certain duty under law? And the answer is yes. Just because you're trying to burglarize a place doesn't necessarily mean you deserve to be killed. There is a special duty that's owed to everybody to do no harm. If somebody's trespassing on somebody else's farmland here in Nova Scotia, and there happens to be a large hole on that property, is there a duty owed to a trespasser to identify that hole, so that the trespasser doesn't actually step in and harm themselves? And the answer is what? It's maybe. Something you're going to understand by going through the materials, taking the exams, is you're going to have to think hard about these situations. Because normally under law, there is no absolute answer. So in the given factual scenarios that you've been dealing with, both from the hypotheticals in the book, as well as the instances from the assignments and the exams that you're taking in this class, understand there are no absolutes. And it's your job to be able to analyze a given situation to come up with why it might be one answer or why it might be the other answer. It's called critical thinking. I mentioned a couple of minutes ago how we analyze under the common law when there is actually no written statute. Well, what happens if there is a statute? The statute will preempt, will cancel out common law for whatever the scope, whatever the extent that the statute covers. Maybe the statute doesn't cover every single instance that would be covered under the common law. However, normally a statute is intended to cancel out the common law, and it's common in statutes to actually have a certain written sentence or provision that says that this statute is intended to cancel out or preempt the common law. And so you'll see on page 269 where it's discussed where there is liability, but under an occupier's liability legislation, including right here in Nova Scotia, or where we have a specific law. And so please review that. And they do give at least a tie-in back to the hypothetical from the beginning of the chapter. You'll see that on page 270, and you'll see exactly how that hypothetical might play out with an occupier's liability statute. Now, toward the bottom of page 270, you'll see that gray box that discusses slips and falls. And we'll discuss whether or not there is occupier's liability if you end up walking into a superstore or a Sobeys or a Pete's or some other supermarket chain. And you've heard about this probably your entire life. There is a wet spot or a slick spot on the floor, and for whatever reason, the person slips and falls and injures themselves. And maybe it's happened to some of you. What is the liability that can be imposed on you? Because these liability statutes may limit the scope of liability, may actually help to insulate or prevent occupier's liability under certain circumstances, notwithstanding what the common law might otherwise provide. So on page 271, we get into the tort of nuisance, and you'll see nuisance defined for you in the right-hand bar. Any activity on an occupier's property that unreasonably and substantially interferes with the neighbor's rights to enjoyment of the neighbor's own property. Now, nuisance is not just limited to how a neighbor is affected. It could be used in other ways where it affects people who are not neighbors, but who may be either driving by, walking by, in other ways just simply being affected without regard to whether or not they can be defined as neighbor. You'll see some examples right near the top of page 271. Noise from a steel fabricator's 800-ton press seriously interrupts a neighbor's sleep. Ashes and unpleasant odors escaping from a rendering company are carried onto neighboring properties because of dated technology. The focus on nuisance is on one's right to enjoy the benefits of land or property uninterrupted by the actions of neighbors. We call it the right to somebody's quiet enjoyment of their property. And that's on a baseline level. But if you were driving by that same plant, that same rendering plant, which emits these unpleasant and possibly harmful odors, then is it a public nuisance at that point? And the answer is yes. That could be defined not as a private nuisance, but certainly as a public nuisance that affects the public at large. Now you'll notice further down, in striking a balance between the parties, the one who's been accused of creating the nuisance and the person who is alleging that they've been harmed by a nuisance, that courts have developed the following guidelines. The interference created by the alleged nuisance has to be substantial, and it has to be unreasonable. And the nuisance typically does not arise where the interference is only temporary. For example, if there's construction and demolition, regardless of how unpleasant it might be, they're normally going to be considered to be temporary, and they're not going to lead to any remedy for nuisance. If you have a specific business that's established right nearby, they come in and they're in the gravel business, and they end up crushing rocks by whatever technique they use, and it's intended to be something that's going to be continuous because that's the nature of that business, then you can make the argument, I think legitimately, very legitimately, that it can create a particular nuisance. In fact, that's why when you see gravel companies out there, including right around here in the Halifax, Nova Scotia area, generally speaking, these gravel producers are trying to establish a buffer to escape being accused of a nuisance to neighboring properties. So they're trying to create a safe zone where the noise and the smell or whatever aerial transmissions won't be able to escape and be in some way cause any type of direct harm to the neighboring areas. Now, moving on to the top of page 272, it further establishes what we're dealing with when we're talking about nuisances. Not all interests are protected by the tort of nuisance. For example, the right to sunlight is an unprotected interest as far as the law of nuisance is concerned. So if you go down to the waterfront in Halifax right now, you may notice over the past few years that Irving Shipyards has established this huge shipbuilding structure right on the water. And when they put that up, there were buildings across the street, residential apartments. And because Irving put that there, it has canceled out the view. It has canceled out, to a certain degree, the sunlight that would normally come streaming through those apartments. Can that apartment building owner, or can those residents who may or may not own the apartment, can they level a nuisance claim against Irving Shipyard? The answer is likely no. Finally, the last bullet point here on the top of page 272. In nuisance actions, courts will consider trade-offs and interests. For example, when the noise is reasonable and for a public good, the action in nuisance will likely fail. And you'll see a good example, and I strongly urge you to review it, the TMS Lighting Limited case, which is located on the bottom of page 272, onto the top of page 273, which deals specifically with this issue of nuisance. That's what nuisance is all about, guys. Review it. It's not that complicated, although there are a multitude of ways in which fact patterns can come up where somebody could allege nuisance. And they're actually really fascinating cases, as is TMS lighting. Next concept that we're going to be discussing is on page 273. It's the issue of trespass. Now, we've already discussed trespass to a certain degree earlier when we were talking specifically about occupier's liability. A trespasser is somebody's wrongful interference with someone's possession of land. That's the definition. So, somebody who is coming on to somebody else's land without lawful permission, or who has gone beyond the scope of permission that has been extended to it. Now, I have every right to be able to come on to St. Mary's University property in order to film this, but if I were to come back into this room, say after midnight, or into this building after midnight, do you think that I would have the same permission, even though I come in here regularly in order to film content and in order to elsewhere on campus to teach? And the answer is yes, I would be a trespasser. The scope of the permission that St. Mary's has given me is limited to a certain normal time and on a certain day period. I could be a trespasser even though I have every right otherwise to be here. I have every right to go into my home. And certainly I'm not going to be considered a trespasser in my own home under any normal circumstances. Or, alternatively, I can go on to private land where I have nobody's approval, and then it's obvious that I am a trespasser. So you'll see the way in which trespassing arises in several ways. There are 3 bullet points. Please, please, please review over those, as well as the final paragraph on that page that gives you good examples of what is involved when there is an allegation of trespassing made. And again, trespassing is what we previously called an intentional tort. It requires you to intentionally interfere with somebody's lawful use of land, regardless of how temporary it might be. You'll see on page 274, it's an important box that I want you to take note of because it deals with environmental perspective and tort actions that relate specifically to the environment. And you'll see 4 different examples of how, at the very least, under common law, there could be environmental torts. And then further, as we discussed before, there could be, if there is some type of leak of a harmful substance, that you could even face strict liability as a result of an environmental tort. So please review that carefully. And then we get into perhaps the meat of this chapter, which deals with, on page 275, torts from business operations. Torts involving customers come up, and again, This involves what you would say are generic torts, but which could also obviously have business implications. And the first two things are two intentional torts that are simply assault and battery. We talked about them briefly before. Please note the actual definitions down there, because again, I need you to revert back to a few chapters ago when I explained what is an assault and what is a battery, but it is well defined for you toward the bottom of page 275. Additionally, I defined for you the concept that's discussed on page 276 dealing with false imprisonment. False imprisonment is, again, another form of intentional tort that deals with you taking an intentional act to prevent somebody from leaving a certain space or threatening them that if they do leave, that certain things could happen to them. Bad things could happen. That's considered false imprisonment. It is detailed for you on page 276, and then the book gives you an example toward the bottom of page 276, as well as the entirety of page 277. And the R.V. Chen case deals with not just the tort liability, but also obviously involves the criminal liability from committing a false imprisonment, which is an unlawful confinement under the criminal code, or dealing specifically with an assault, which is also an assault under the criminal code. So you'll see those two cross sections there in the Chen case. Please review it. Chen, by the way, ends on the top of page 277. Also, Chen ends on the top of page 278. On page 278, we deal with yet another general tort that can have business implications. It's the tort of deceit. It's a false representation that's intentionally or recklessly made by one person to cause damage to another. We generally know what the definition of deceit is. Somebody could be sued for deceit depending upon the circumstances. Was there an intent to deceive, or was a statement or action taken recklessly that had the effect of deceiving another? Getting off to business torts, toward the bottom of page 278, the first one we come to is dealing with this notion of passing off, which is, as defined there, presenting another's goods or services as one's own. Please look at it carefully, and then note how the Supreme Court's analysis in the Ciba-Geigy Canada case impacts whether or not this could actually be seen as passing off. The most important thing relates back to our hypothetical in this chapter, and you'll see goodwill or reputation, as well as a misrepresentation, whether expressed or implied, are really the issues that come about when in this notion of passing off. Perhaps one of the more used torts, ones that you find in a court of law being sued for, are interference with contractual relations, and then separately, even though it's not mentioned specifically in this chapter, tortious interference with business relations. If you remember, going back, we discussed at least a couple of times how someone can be sued for actions that might constitute breaches of contract and at the same time be sued for torts. It's not exactly like that when you're dealing with interference with contractual relations as well as tortious interference with business relations. However, the same set of events, the same actions, could actually result in somebody being sued for both such torts. Here we're dealing specifically with, and I will limit my comments specifically to what's in the book, interference with contractual relations, in which case it's an incitement to break the contractual obligations of another. You have to intend to in some way do something that would impact the pre-existing contractual relations between at least two other parties involved. And you can imagine the setting might be where one business attempts to steal the customers of another business where there's already a contract between the other business and its customer. If you're going to incite somebody to breach contractual obligations with another business, the business that's been harmed from that can sue the offending business for intentional interference with contractual relations. The last tort we're going to discuss, and it's one that I referred to when we started this chapter, is the tort of defamation. This is the last part. This, to me, is the end of chapter 12, where we talk about the tort of defamation. Defamation combines two separate concepts into one term, defamation. If you say something that's untrue about somebody with the intent to injure them, and that injury is created, if you say something, the spoken word, that's called slander. Meanwhile, if you write something down with the same intent as you would in a case of slander, but it's in writing, it's referred to as libel. Now, defamation combines those two concepts, and you'll see the actual definition there on page 281. The public utterance of a false statement of fact or opinion that harms another's reputation. And so, understand the elements to this. The utterance has to be public. It has to be published to the public or to others, even if it's not the public at large. It has to be made to someone else. It has to be false. It has to be a statement of fact or opinion that harms another's reputation. The person who may be suing for defamation is going to have to actually show that harm, whether it's reputational, whether it's financial. Most of the time you're looking for something that has financial consequences, because how do you award damages necessarily unless you could show the actual harm to somebody's overall reputation? If you'll note, the key ingredients to the tort, as recently confirmed by the Supreme Court of Canada, are as follows, and you'll see 3 bullet points. The defendant's words were defamatory in that they would tend to lower the plaintiff's reputation in the eyes of a reasonable person. The statement did, in fact, refer to the plaintiff, and the words were communicated to at least one other person beyond the plaintiff. The plaintiff will then succeed if the defendant is unable to establish a defense to the action. And they give an example. If the defendant can show that the false statement is substantially true, he has a complete defense of justification. And there are 3 defenses that are outlined on page 281, and they involve justification, qualified privilege, and fair comment. The biggest defense to an allegation of defamation is what? Truth. If something's true, you're not going to be held liable for defamation of character. Look at the other 2 defenses. Qualified privilege is based on the defamatory statement being relevant without malice and communicated only to a party who has a legitimate interest in receiving it. So you'll see amongst here, from a business perspective, a potential defamation scenario occurs when an employer provides a reference for an ex-employee. If the letter contains a defamatory statement that's true, the employer may have the defense of justification. Other defenses involve qualified privilege. If the employer's statement is relevant, and it's made without malice, and communicated only to a party who has a legitimate interest in receiving it, the defense is established. So if I have, for instance, a lawyer who used to work with my firm, and maybe I wasn't very high on that lawyer's skills, or maybe I questioned whether that lawyer was as honest as he or she should be, and a potential new law firm contacts me and asks me about that lawyer, and I comment that I may have some concerns with overall for the honesty of that lawyer, and that the new law firm should be on their guard, can I be sued for defamation? I could be sued for it. Do I have a legitimate defense? And the answer is yes. Qualified privilege would be my defense. Now, fair comment is the other defense that's discussed here in the book. You'll see it defined toward the bottom of page 281. It's established when the plaintiff cannot show malice and the defendant can show that the comment concerned a matter of public interest, was factually based, and expressed a view that could honestly be held by anybody. The key concept in here is matters of public interest. So, if I have a genuine concern, say about the fact that, at least as we're filming this, that Donald Trump is running for President of the United States, and I comment on my concerns that Donald Trump is running because of yada yada yada, can Donald Trump sue me for such comments? And the answer is no. Or yes, he can sue. Would he be able to establish defamation? I would be commenting normally on something that was of public concern, namely Donald Trump potentially becoming the President of the United States. And that would be the limitation of it. Plus, and we're not going to go into it, there are certain other defenses because of the fact that Donald Trump, like it or not, is a public figure. And generally speaking, when you're dealing with people who are either considered public figures or quasi-public figures, that the ability to fend off a defamation claim is a bit easier in a legal context. So guys, that's defamation. Now, something that you should understand as well is defamation can occur, especially in the computer age, in a variety of different contexts. And in fact, it's easier now to defame somebody than it's ever been before because of the internet. It's easy to get onto Facebook or Instagram or Twitter or wherever, whatever website, and post a comment that could potentially impact the other person because it's false. So the potential to defame somebody is always out there. And we always have to be guarded about that, especially if you're running your own business. You guys are probably familiar with a website called Yelp, and it's a wonderful website. But it can be used for harmful purposes too, especially if there is a customer or somebody else who's not even a customer who has an axe to grind with the actual business itself and wants to in some way convey some type of harm. And you also have to understand how much more difficult it is to be able to establish who made that comment when it's in an online setting. Trying to come up with some way of identifying the person who posted the potentially defamatory content can be very difficult. So it could be as something as mundane as Rate My Professor, which some of you may have heard of, and you're welcome to go on and check out my ratings on Rate My Professor. And there have been some students who I believe have, in the past 13 years, have said things that are patently untrue about me on Rate My Professor. Was it defamatory? Yeah, it was probably defamatory. It was defamatory because it was untrue. It was intended to hurt my reputation, but at the same time, did it have any long-term effect? Was there actual damage because the occasional student may have said something nasty because they got a poor grade? There was no harm to my reputation. We are all subject to this now. Regardless of how good we might be as people in our particular profession, we're all subject to this. And so with that additional power that the internet provides to us becomes greater responsibility. Let's go on to page 282. Responsible communications, a matter of public interest, are further discussed. And then we get up to this notion of absolute privilege. It's a defense defamation that relates to parliamentary or judicial proceedings. As a lawyer, I have, and I can certainly say that a judge has this, as does an elected representative, a certain privilege when things are communicated within a courtroom setting or within a legislative setting to be able to say things without the fear of actually being sued by the other side. And that's what the absolute privilege provides. It's not qualified privilege, it's something that's absolute. Should I be able to make an argument about the other side in a case without the fear of being sued by that other side? And the answer is what? Yes. There's a public interest in giving lawyers the right to be able to speak their minds freely on behalf of their clients. There's a public interest in giving elected officials or judges the ability to speak their minds on issues within a case or on issues of public concern. That's really chapter 12. So you can see there are a couple of other torts that you could actually reference on pages 284, injurious falsehood and product defamation, as well as intrusion upon seclusion. But for the most part, you'll see that these are the business torts that you're going to have to be most concerned with. Now, what's great is on page 287 in figure 12.1, they give you a summary of chapter 12 business torts. This is what I would call your cheat sheet for understanding this chapter and getting through potentially assignments and even the exam. So please reference it. It's there for your benefit. Don't ignore it. It gives you a quick and easy understanding of the concepts that we have discussed today. So with that, that closes out Commercial Law 1. And I wish you guys all the best and good luck on your exams. And I have had the pleasure of being able to provide you with these materials. Thank you.